In today's video, I'm going to take a look at the contract, which would typically be the type of contract that's provided when you go to buy a property at auction. So this is a very specific type of contract, and it's a very specific way of buying property. You can buy by private treaty or you can buy at public auction. Most of the auctions in the last number of years in Ireland would be receivers or banks or mortgagees in possession, repossessing properties and selling them. That particular contract, though, takes a fair degree of looking at or reviewing, and you would be well advised to approach it with a fair amount of caution. Recently, however, here outside Enfield, there was an auction by a receiver over a certain individual who had been unable to pay his debts. As you can see there, Anthony Mooney, certain assets in receivership. It was Tom Kavanagh was the receiver appointed by Tanager, and Tanager had bought the loan from, I think, the Bank of Scotland. But in this video, what I want to do is look at the actual contract and what you need to be very much aware of. And I've made a video before about buying at auction. This one, though, is specifically looking at a receiver sale, a mortgagee in possession sale, a repossession sale, and what you need to be careful about. Firstly, you need to understand that the general conditions of sale of the Law Society of Ireland, contract is made up of general conditions and special conditions. The general conditions are the same. They are standard issue in the Law Society contract from one conveyance to another. However, what distinguishes one sale, one contract from another in any conveyance will be the special conditions. So the special conditions are going to be drafted by the vendor solicitor, and they are what you need to be careful about. So we'll have a look here. As you can see here, there's a vendor, Anthony Mooney, certain assets in receivership. Tom Kavanagh was the receiver, so he was appointed. Philip Lee in Dublin was the auctioneer, or was the solicitor rather, for the vendor. So you can see there, acting by Tom Kavanagh as receiver. So this gentleman here is the registered owner of the property, but Tom Kavanagh has been appointed as receiver by the lender. You'll note here, closing date 2 weeks from the date hereof. So generally you need to have your finances in order before you buy a property at auction, because if you don't, you could be in for a very rude awakening. A, there's no way out, and B, you do have to complete within a relatively short period of time. You may get a little bit more time, but generally you're looking at 2 weeks to 3 weeks as the closing date. So all that and those, the premises known as Kilmore, Enfield, County Kildare, etc., etc. You'll see there folio 42451F into County Dublin. That's clearly a mistake, because the property is actually in County Kildare and it has a postal address of Enfield, but County Dublin is incorrect. But in any event, we'll overlook that. Then you have a document schedule here, so you'll see appointment of receiver, the planning documents, BR cert and so on. We won't worry about that for the moment. It's the special conditions we're concerned about. Special condition 1 is a boilerplate sort of a thing. You'll have that in every contract. Special condition 2 is the same story. Special condition 3 is the VAT special condition. But in respect of a second-hand residential property, the VAT does not apply. So the VAT special condition is deleted. Special condition number 4, title. Title to the property shall consist of folio blah blah blah, County Dublin. Again, that's a mistake. It's not County Dublin, it's a County Kildare or County Meath. I think it's County Kildare. But in any event, that's just a typo or it's a mistake. You'll see here now vendor as receiver. So this special condition points out that Tom Kavanagh is the receiver. He was appointed by Tanager DAC, the lender, as receiver, and there's a deed of appointment and so on and so forth. And this special condition basically says that the receiver will be selling and you accept that. The assurance then is the deed of transfer at the end of the successful, or at the end of the auction, and at the option of the receiver, the property will be transferred on completion by way of a deed of assurance from the vendor, that's Mr. Kavanagh, or perhaps a deed of assurance from the lender, or perhaps a deed of assurance from the receiver. But that's just making provision for the transfer of the property from a legal perspective at the end of the auction. See the planning condition here. Notwithstanding anything hereinbefore or hereinafter contained, General Condition 32 shall not apply, and this agreement shall be read and construed as if the said general condition had been wholly omitted. General Condition 32 is one of the few warranties that you get in any contract, and it is a warranty that planning is in order. So you'll see here that the receiver is omitting General Condition 32. You are getting no comfort whatsoever in relation to planning according to this special condition. However, it says, without prejudice to the foregoing, the purchaser is furnished with documents referred to in the document schedule. So there is some documents. There's a grant of planning permission, there's a certificate of compliance with permission, but there's nothing in relation to any further development that might have been carried out after the original construction of the house. So that is where this condition is very, very important. The receiver is saying basically, I know nothing. I'm giving you these documents here that's referred to in the document schedule on a without prejudice basis, but I know nothing. Go and do your own planning research. So that is something you'd be very well advised to do beforehand. Carry out your research, carry out a planning search, and see what the story is as best you can. The charge. So the charge is the mortgages on the property. The property is held subject to a mortgage in favour of Bank of Scotland. That was then sold, I think, to Tanager, and Tanager have appointed the receiver. So once the property is sold by the mortgagee in possession, that is Tanager, then the charge will disappear off the folio like snow off a hedge. Family law declaration. Normally you get a family law declaration, but in this case the receiver will be giving it to you, and he'll be confirming that it's not affected by the Family Law Acts to the best of his knowledge and information. Clearly the receiver has limited knowledge, however, because he's never lived in the house and he's only just been appointed to sell it. Explanation of acts and searches. Neither the vendor nor the receiver will be required to explain or discharge any judgments or lease pendants, charges, mortgages, etc. that are on the title registered since the date of the mortgage. So the vendor or the receiver are not going to explain any searches that you might do. Normally you would do searches on closing, and the vendor or vendor solicitor will explain the searches. That's not the case here. Special condition 11 says it's a receiver sale, and you'll see here that the receiver has a limited knowledge of the property, and accordingly, so he's limited knowledge, therefore the declarations are going to be limited, the identity is going to be limited or constrained, and the boundaries then, there's no warranty from the vendors and the receiver. Again, rights, conditions and liabilities limited, environmental limited, non-title information limited, disclosure of notices limited, development limited. In other words, the receiver is selling, it's a receiver sale, he's limited knowledge, and he's putting you on notice of that by way of this special condition before you go and bid on the place. So you don't turn around afterwards and complain about X, Y or Z, or the identity of the property, or the boundaries, or declarations, or anything of that nature. He is protecting himself here, and you need to be clear about what's going on here. Now, speaking of a limitation or limited, again there's a limitation on liability, so the liability of the receiver will be limited to the amount of cash, etc., etc. Exclusion of personal liability, another limitation. Risk insurance, the vendor's liability is limited. State of the property, the purchaser shall not call upon the vendors or the receiver to remove any rubbish or materials, spoil, waste, fluids, etc. Again, the receiver is protecting himself. Notices, any notices given, again that's a limitation of a certain type. No assignment, the purchaser shall not be free to assign the benefit of the contract to anybody else. Objections and requisitions, the purchaser acknowledges that he has been given replies, but again, for the avoidance of doubt, all of these replies will not be replied to, etc. Again, that is a limitation of the potential exposure or liability of the receiver. Again, you need to be very, very careful about that. Miscellaneous clause, entire agreement and representations. This is a very important clause. The purchaser agrees and accepts that no statement or measurement contained in any brochure or advertisement issued by the vendors or any agent shall constitute representation. In other words, regardless of what you read on the website of the auctioneers, regardless of what you read on the brochure of the auctioneers, no statement or measurement can be relied upon or constitute a representation. Therefore, this is the whole shooting match. This contract is the entire agreement and the entire representations. You need to be clear on that. Number 21 is a sort of a boilerplate clause. Number 22 says the vendor gives no warranty as to title, state condition, fitness of contents, loose furnishings and so forth. Again, that's another limitation on the liability or potential risk or exposure of the vendor, that is the receiver. And then the auctioneer and the vendor solicitor will hold the deposit as agent for the vendor and not as a stakeholder. Again, it's a limitation on the liability or potential liability of the receiver as vendor. Then we move on to the general conditions. As I said to you at the beginning of this video, general conditions will not vary from sale to sale or from contract to contract. They'll be the same. Where the rubber hits the road is in the special conditions, and the special conditions are what you need to be very, very careful about when you are looking to buy a property at auction. I'm going to put another video up here someplace in relation to buying at auction and the dangers of doing that, but I hope you find this video useful. If you do, I would appreciate if you give it a thumbs up down below. But the key thing you need to remember, if you're buying at auction or thinking about buying at auction, do your research in advance, because you will see from the special conditions in this contract, and this is typical of the type of contract involved, you will see that the liability and risk of the receiver is fairly limited and is well protected. You might get a bargain, but you need to do your homework first. Hope you find this video useful. If you do, give it a thumbs up down below. Thanks a lot.